A Superior Court judge has dismissed the latest legal challenge against North Carolina's Certificate of Need law. And joining us now with analysis of this ruling is John Guze. He is Senior Fellow in Legal Studies at the John Locke Foundation. And John, sounds as if in some respects this is good news and bad news, mostly bad news, but a little bit of good news for Dr. Jay Singleton, the plaintiff in this case. Bad news, his case gets dismissed, but at least it was done quickly.
Right. So it'll go up to the Court of Appeals, I'm quite sure. And it was going to end up there sooner or later anyway. So at least we're not wasting time waiting for the judge to make a decision. Because if he had denied the motion, I'm sure the state would have appealed it anyway.
Now, take us through the highlights of what you took from this nearly 2-hour proceeding, the state making its arguments about why this case should be thrown out, and lawyers from the Institute for Justice who are working with Dr. Jay Singleton saying, no, this case should be allowed to proceed, and here's why. What were some of the highlights that you took out of this?
Well, the state had two arguments why this case should be dismissed. One of them was that Dr. Singleton had failed to exhaust his administrative remedies. They're saying that before he should have been allowed to complain about this law, he should have had to challenge the Certificate of Need requirements all the way through the administrative system. He should have had to apply for a Certificate of Need, even though he'd already been told that none were available. When it was denied, he would have had to appeal that. And eventually there would have been an opportunity for other groups like the hospitals that are being represented here to come in and say he shouldn't be allowed to get one. The whole process, had he decided to do it, would have taken many years. It would have cost hundreds of thousands of dollars. And almost certainly he wouldn't have gotten a Certificate of Need at the end of it anyway. In our brief and in his lawyer's brief, we said that's punishment in and of itself. That whole process itself is a barrier to entry into this this type of occupation, and that in itself makes it unconstitutional. Judge Ofluta actually accepted that argument. He wouldn't dismiss it on the basis of the failure to exhaust administrative remedies claim. But the other reason the state said this case should be dismissed was that he'd failed to state a claim for which relief could be granted. And the reason they said that was because they said if a North Carolina law is challenged on the constitutional basis, it can stand if there's any conceivable rational basis for it. That means doesn't have to really be very rational, but if the court can conceive of any possible legitimate government goal that could conceivably, even if wrongly, but conceivably have been rationally thought to be furthered by this law, then the law should stand. Now, that certainly is the standard at the federal level. One of the issues that eventually is going to get decided by this case is whether that really is the standard of the North Carolina law. But because of a case that was decided about 10 years ago, a similar case in some ways, that where the challenge failed, Judge Ofluta said, no, I'm going to allow that. I'm going to grant that motion on that basis and let the Court of Appeals tell me whether or not that's correct.
One of the things that came out of the argument from the plaintiffs in this case, the lawyers arguing on behalf of Dr. Jay Singleton of New Bern, who wants to be able to perform more outpatient surgeries in his facility there in New Bern, is that perhaps North Carolina courts should be using a different legal standard than this rational basis test. Tell us about that.
Well, I think that's exactly right. I mean, that's what Dr. Singleton's lawyers argued today. That's what they argued in their brief, and I think that's exactly right. Look, this rational basis test, it's not written in our Constitution. It's not written into the federal Constitution either. It was invented out of whole cloth by the U.S. Supreme Court back in the 30s because they wanted to find a way to uphold a lot of economic regulations that the Roosevelt administration was promulgating at the time. So they just said, you know what, henceforth, we're going to just defer to legislators. They call it judicial deference. And we're just going to assume that these laws are constitutional unless we simply can't see any rational basis for them. Now, the federal courts adopted that in the 30s. There's no particular reason why that should apply to the states. And in fact, North Carolina didn't start using it until I think the 50s. There were still a lot of cases in the 50s in which the courts were being much more rigorous about even economic regulations. So I hope that with this case or with some case, one of these days, the Supreme Court of North Carolina says, you know what? Rational basis doesn't apply in North Carolina. We're going to use some more reasonable standard, some standard that gives plaintiffs an opportunity to challenge laws, even if all they're doing is limiting their ability to provide economic services in the marketplace.
Now, one of the things that we said earlier is that however the judge ruled in this case, it was likely to be appealed. Does it make a particular difference as this moves forward that the judge allowed the state's argument and had the motion to dismiss rather than saying, no, I'm going to let this go forward and have the state appeal that ruling? In other words, once it gets to the next court, what difference does it make for Dr. Singleton and for the state that the judge accepted the dismissal rather than rejecting it?
Well, Dr. Singleton would be in a better position if the court had denied the motion and then the state had to appeal. Appellate courts prefer not to overturn trial court decisions if they can avoid it. It's partly, professional courtesy, but it's also, it's just, it's emotionally less satisfactory. They don't want to stir the pot if they can avoid it. Letting things stand is a fundamental approach to the law that all courts want to do it if they can. So this will make it harder, but I don't think it'll be insurmountable, because the last case, the common law case that was decided in North Carolina, only got as far as the Court of Appeals. And so that's the right place for this to be considered. I think they'll listen to both sides. I don't think they're going to be prejudge it just because the Superior Court judge decided it one way rather than the other.
Well, as Dr. Jay Singleton of New Bern continues to pursue this legal case, we know that one person who's going to be watching very closely is John Guze. He is Senior Fellow in Legal Studies at the John Locke Foundation. Thanks so much, John.
Thank you.